It is now my pleasure to turn the webcast over to Keith Schmidt. Mr. Schmidt, you may begin.
Thank you, Monique. Good morning, everyone, and thank you for joining us this morning. My name is Keith Schmidt. I'm the Executive Vice President and Head of Premier Wealth Management at Zions Bank. This area of the bank is responsible for the custom solutions we provide to our high net worth individuals and families. Services such as private banking, investment management, insurance, financial planning, and what we'll be covering today, estate planning and trust services. As a part of our Family Business Initiative, we're pleased to host this webinar, and it is my pleasure to introduce the President of Zions Trust and the head of our Wealth Strategies Group for Zions Bank. Many of you have had a chance to see her present at our Family Business Seminars. She's both a CFP and a CPA, and today we'll be covering the basics of estate planning. It is again my pleasure to introduce to you Rebecca Robinson. Rebecca?
Thank you very much, Keith, and welcome everyone. Good morning. Over the next hour, what I'd like to do is spend some time with you going over the very basics of estate planning. I think a lot of times when we hear about estate planning, we hear about a lot of the famous cases out in the media. Some of them that come to mind is Michael Jackson had a trust and he failed to fund it, or Sonny Bono never wrote a will and there was a lot of family acrimony after his passing. But I think it's important to note that although that is part of estate planning, for almost everyone out there, there is some need to have some type of estate plan in place. So let's start by saying, what is an estate plan? I think it's important to note that estate plans come with varying levels of complexity. But if we put it most simply, an estate plan is simply a map of how you would like your personal financial affairs to be handled in the case of either incapacity or death. And this is not just how you would like those affairs to be handled, but also the implementation of the strategies that will allow you to fulfill those objectives. So we start with who needs an estate plan. Chances are almost everyone needs an estate plan, but let's talk about some of the things that may indicate you're in need of an estate plan. First is, as we mentioned, estate plans are not just for the wealthy. But also, a secondary piece of this is without an estate plan, you don't have the ability to control what happens to your property or what happens to you in the event that you become incapacitated or you were to pass away. Generally, people create estate plans because they want control. They also want to make sure their wishes are clear and they want to avoid family disputes. Some of the reasons I found when people avoid getting an estate plan in place, one is that it seems very complex, but then the second one is a difficulty in dealing with family situations. And I think our families today can be more complicated than ever with second marriages and children from different marriages. And what I hope we take away today is, although it can be difficult to deal with, it's not impossible. But in the event we don't deal with it, the issues will still need to be addressed. And that can lead to a lot of disputes, and disputes between family members and others when it comes to estate situations are extremely expensive. So with that, then let's talk about when you especially need an estate plan. I think a big one is if your spouse isn't comfortable with financial matters or is not feeling overly capable with financial matters. And so I'll give you a great example of this. In families, there tends to be one person who's more willing to say yes or doesn't want to say no. If you feel like your spouse would be approached by family members, if your spouse is so generous that they would look out for the well-being of others before they look out for themselves, you may want to put an estate plan in place to help protect them and financially in the event that you were no longer there. Another one, if you have minor children, and then a will allows you to name a guardian for those minor children, and that's a suggestion to the court as to who you would want to look after your children. I think this is important as well because there are certain assumptions that may be made. For example, oftentimes it is a family member that you would name. But I've also worked with just as many cases where individuals might prefer a friend, and if they haven't made those wishes known, the court really doesn't have anything to go on in the event something were to happen to you. Another one is if you have an estate that will be subject to estate taxes, and we're going to go into this a lot in a little bit, but I think it's important if you have a taxable estate, that starts to make things more complicated. Another one, if you own property in more than one state, so if you have a vacation home in Idaho and a home in Utah, you would have to probate your will in 2 states. It's called ancillary probate. We'll talk a little bit about that. And then another one, if financial privacy is a concern, we'll talk about how to deal with that, as well as other distinct needs, such as planning for the succession of a business. All of these things require planning, and they require some documentation. And if you have some of these situations, it's very important that you address that. So let's start by looking at a few basic estate planning concepts. So at the high level, we're looking at 2 things, planning for incapacity and planning for death. And when we talk about planning for incapacity, we have health care issues, we can talk about property management, wills and probate, some of the tax basics, lifetime gifting, trust, and ultimately the role of life insurance in an estate plan. So I'm going to start with planning for incapacity. And I think when we talk about incapacity, it's important to note that incapacity can happen to anyone at any time. We often think of incapacity as being associated with aging, but another example might be if you were in an accident. You were out biking one day and having a great time mountain biking, and you're in an accident, and you're in a coma for several months. In those cases, how would your doctor know what medical treatments you would or wouldn't want, as well as how would your personal business be transacted if there's no one who's authorized to sign for you? If you have bills that are due, if you have options and stock things at work, you need someone designated to make those decisions. And that's really what planning for incapacity is. One of the things that happens if you have failed to plan for incapacity is that the court will need to assign a guardian for you. I have a client I'm working with right now that ended up in this situation with her parents, and it's a very difficult spot to be. She has very limited authority, and each time a decision needs to be made, she has to go back into court to do so. If prior to their incapacity some documents had been put in place to allow her to act, the entire family, I think, would be in a much better position and wouldn't also be spending the time as well as the financial resources that it takes to address a court every time something's needed. So when we talk about planning for incapacity, there are 3 documents here. I'm going to really focus on the first 2, and then I'm going to throw one more in because it's getting to be college season, and I think it's important just to highlight for people on the phone. So let's first talk about our health care directives. A health care directive means you're incapacitated. You are still alive, but you're unable to make your health care decisions. So the individuals that you name in this document would step in and make decisions for you. And oftentimes you may have all of these documents or one of these documents dependent on the state where you live and which of the documents they'll follow. So there are really 3 different ways to address incapacity: a living will, a durable power of attorney for health care, which is oftentimes called a health care proxy, and then a DNR or a do not resuscitate order. Let's start with a living will is a document that lists the medical treatment that you would or would not want under particular circumstances. It may state that you don't want life support if you were in a persistent vegetative state, and you have to think about a lot of possible scenarios and when you would or wouldn't want certain actions to be taken. I think there's a couple of very relevant examples. Probably the most famous case is the Terry Schiavo case, where she had failed to put a living will in place, and her parents and her husband spent probably, I believe it was almost 20 years at odds over what it is she would have wanted, because at that point, unfortunately, she'd had a stroke and she was silent to it. I think just even within the last few weeks, we had the Casey Kasem example, and you see a person who's going through end-of-life care and so much discord within a family, because once again, these documents weren't in place that someone could look to and say, what is it he wants? We're looking at 2 feuding family members determining what they think he wants versus what he stated. A second document is a durable power of attorney for health care, or otherwise known as a health care proxy. This document lets one or more of your family members or other trusted individuals that you name make medical decisions for you. So unlike a living will, this directive gives them broad power, now not unending power. They still act with a physician and with the overwhelming opinion of 3 physicians, things like that, depending on what's going on. But it gives them the ability to step in and act on your behalf. And then finally, the do not resuscitate order. These are very common when we talk about end-of-life care, hospice situations, terminal illnesses. So we're not going to get into those in detail because they are also very hospital and very state-specific, but I do think it's important for you to be aware of them. One document that is not mentioned on here, but I do want to touch on, is a HIPAA release. So it's the Health Information Protection and Privacy Act, I believe. As we prepare to send kids off to college, and it's that time of year, I think it's very important as a parent to make sure that you have a HIPAA release on file. Because as much as we don't like to necessarily think of our 18-year-olds as adults, legally they are adults, which also means their health insurance information is private unless they have waived that right to privacy via a HIPAA release. Had a client whose child unfortunately ended up with some mental illness issues while in college and was taken to a hospital, and because that HIPAA release wasn't signed, for a few days they couldn't even be told what hospital, and when they finally tracked down which hospital she was at, they had very limited access to information without some court intervention. So as you do this, there's a lot of information online for state-specific, as well as a lot of universities have done a good job also putting these forms out there. So just keep that in mind if you are sending kids off to college, or even if you have young professionals, young adults who are working, who don't have a significant other, that, you know, a marital situation where that information would be available. So when we talk about planning for incapacity, we just talked about planning for your health care decisions. There's also decisions to be made about your property. So there are 3 ways that you can plan to have your financial affairs taken care of for you in the event you can't take care of them yourself. You can arrange to own your property jointly. You can have a durable power of attorney or a durable power agent that could act on your behalf, or there's also a living trust that you could utilize. So if we start with joint property ownership, basically joint ownership allows the individual the same access to property that you have. For example, if you and your spouse have a joint checking account, if one of you can't make deposits and write checks, the other one is fully authorized to do so. From an estate planning standpoint, it's important that your titling of assets be done in conjunction with your estate plan and the necessary complexity. Because I oftentimes will see a will that directs property to pass one way, and then when we look at the titling, it's joint tenants with rights of survivorship passing a different way. The joint tenancy will override your will. So it is a method of managing property, but make sure it is also working in conjunction with your estate plan. The next one is a durable power of attorney that, much like a health care power, allows family members or other trusted individuals to make certain specified financial decisions on your behalf. And then, finally, the living trust. Using a living trust is another very common strategy, and we'll talk more about trust later. You may have heard them also referred to as revocable living trusts, but it's all the same type of concept. These can be used for planning for incapacity as well as for avoiding probate, and we'll touch on those in a little bit. So another common question is, what happens if you die without an estate plan? And I think as we just touched on, if you were to pass away without an estate plan, certain property is going to pass by beneficiary designation. So if we think through things like our IRAs, our 401ks, usually have a beneficiary designation. Life insurance will have that type of designation. Joint tenants with rights of survivorship. Assets that are titled that way will pass by automatically by title. Then from there, your remaining property, the state intestacy laws, and to die intestate means to simply pass away without a will in place. that will be dependent on state laws, and the state laws vary from one place to another. One step back to the beneficiary designations, keep in mind that if you have recently gone through a divorce or, even in the past, or there have been other changes in your life, it's a good idea to revisit those beneficiary designations. Because in many states also, if you have named a beneficiary, even if you are no longer married or things have changed, the company is obligated to pay out to the person named as your beneficiary. So if you have had changes in circumstances, if a spouse has passed away, make sure you go back and revisit those as well as part of your overall estate planning. Just to give you an example of what it means for something to pass intestate, and different states have different laws. If we talk about Jimi Hendrix passed away at the age of 27. So, as a young person that time, obviously didn't have a will, didn't think about it, didn't think about needing it. Well, he and his brother were very close, and he and his father were estranged. But because he died intestate, meaning he didn't have a will, the state laws stepped in and left all of his assets to his father. Subsequently, his father left all of those assets to his own adopted child from a later marriage and completely cut Jimmy's brother out. I think if you went back to his intentions, I don't think that's what he would have wanted to have happen. So it's important, if you have desires and you have things that you would like to have happen, that you name and spell out what those are. So we're going to talk a little bit about wills. And a will is probably the most vital piece of anyone's estate plan. At its most basic form, a will is a legal document. It directs how your property will be dispersed when you die. It also allows you to name an executor who can carry out your wishes. And in addition, your will lets you name a guardian for your minor children, as we mentioned earlier. You can also create trusts in your will to handle assets that would be left to a minor, or a lot of other things can be created within your will. You can also use a will to accomplish other estate planning goals, such as transfer tax planning. Few notes: to be valid, your will must be in writing, and it must be signed by you. Your signature needs to be witnessed, and then the number of witnesses required will vary by state. And it's also very important to know that you need to do this right, because if you're not careful, your will could end up being invalid. One of the questions I get asked is, when is it okay to go it alone and do my own will, and when do I need a professional? And the best advice I could give is that you always need a professional. There are estate planning attorneys that work with clients all over the spectrum in a variety of ways. So if you have a very basic situation and you need a will, there are attorneys who will specialize in that. If you have a very complex situation, there are attorneys who specialize in that. But I think we have an example of Warren Burger, who's a former U.S. Supreme Court Justice, so we think obviously highly capable. He made the decision to write his own will and attempted to be very, very brief with it, 176 words. The fighting and the issues that ensued because it was not done in line with estate planning law, as well as it lacked some of the complexity needed to really explain his wishes. There was almost $500,000 spent on legal fees with his family. So I think if a Supreme Court justice is not able to write his own will and have it stand up, I would suggest the rest of us work with a professional as we do it. So let's talk a little bit about the probate process. And essentially, probate is the process of getting a signature from a dead person. They need to go through probate. You take your will through probate in order for the court to determine that a certain individual can act, and that's usually the executor named within your will. The rules vary from state to state. In some states, smaller states are exempt from probate, and also it varies state by how complex and costly and time-consuming the process is. I live in the state of Texas. In Texas, probate is a relatively easy process. There are still reasons to avoid it, but it's an easy process. For individuals in California, probate can be a very expensive process. So it's important to be aware of the rules where you live and make a determination then if you would like to be able to avoid the probate process, and we'll talk about how that's done. So probate starts with someone filing a will with the probate court, and then that individual, the court will oversee the settlement process. The individual named as the executor is usually the one who does this, and once the will is filed with the court and validated, your executor can go about the business of settling your estate. So what this means is this executor has to collect all of the monies that you owe, all of your accounts, all of your assets, and see to it that all of your bills are paid, that tax returns are filed, estate tax returns are filed if necessary, and then distribute the property in line with the way it's stated in your will. Oftentimes things can go smoothly with this process, and it can last anywhere from a few months to a year. If your estate is complex or if it's contested, it could go a lot longer than that. One of the things also to keep in mind as you name an executor is being an executor is a job. It is not an honor, and it's not an honor to bestow upon someone. It is absolutely a job. And if you have a complex estate, you may want to name a professional trustee, so someone like a Zions Bank to step into that place, or you may want to give your executor the right to hire someone to help with that process. So a lot of people wish to avoid probate. And when we talk about some of the pros and cons that are out there, we'll look first at some of the pros. One, times and costs are typically modest when we talk about probate. Second, a probated will does have court supervision, which helps you have some assurance that your wishes will be carried out. And then three, probate offers some protection against creditors. As part of the probate process, your creditors are notified and they have to make a claim against your estate. If they don't do so in a timely manner, it becomes much more difficult for them to collect. But some of the cons, as we mentioned, it can be time-consuming and expensive. There can be delays, and there can be delays in transferring the title to assets that your family and your heirs may need. There are fees, probate fees, there are court fees. You'll have oftentimes legal fees that are associated with it. There's ancillary probate, so if you have property in more than one state, you'll have to probate that in each state where the property is located. And finally, I think the biggest reason I see people avoid probate is around privacy concerns. Probate is a public process, and your assets and all of the other pieces associated with it are part of the public record. So for individuals who either have complicated family situations, who may have large estates, or have other reasons that they would like things to remain private, the probate process is often something they will seek to avoid. So then the question becomes, well, can you avoid probate? And the answer is yes. The major ways property is passed outside of probate is either by owning it jointly with rights of survivorship, by ensuring that all of your beneficiary designations are up to date and complete, such as IRAs, retirement plans, and life insurance, or by putting property in a trust and making lifetime gifts. So when we talk about a trust, and we'll touch on it a little more, there are living trusts or something called revocable living trusts. These type of trusts are created for the heavy purpose of avoiding probate. Your assets are transferred during your life. During your lifetime, you can utilize these assets for your own purposes. And then at the event of either your incapacity or death, the trust really springs into action and can help settle your estate. The trustee in that case already has been given the right, and they don't have to go to court to obtain that right. So let's switch gears for a minute, and let's talk a little bit about estate taxes. So I think over the last few years, we've probably heard more in the news about estate taxes than we'd heard in the 20 years before. And it's because there have been a lot of changes and sunsetting of rules and a lot of uncertainty around where the estate tax would go, if there would even be an estate tax at one point. So when we talk about estate taxes, there are three types of federal taxes that may be imposed when your property is transferred, either during your lifetime or at death. And we call these collectively transfer taxes. These are gift taxes, estate taxes, and the generation skipping tax, which is sometimes you'll hear referred to as the GST. We're going to discuss transfer taxes on the federal level only, but be aware some states do impose their own taxes as well. So you may want to make sure that as you're going through this process, get information about transfer taxes imposed by your particular state of residence as well. So the first one, if we talk about federal gift tax, every individual has a gift tax amount that they can give away every single year. Let's get over to the right slide here. Each individual has $14,000 a year in annual gift exclusion that they can give to as many individuals as they want. So I could give $14,000 to my sister, $14,000 to each of my nieces and nephews, $14,000 to my gardener. You can give this away to as many different individuals as you want. You also, during your lifetime, have the ability, if you choose to use your overall exclusion, above that $14,000 per year to give $5,340,000, and we'll talk about where that number comes from in a minute, $5,340,000 during your lifetime as well. So this exemption to be able to give away this amount during your life is the largest that it has been in history, and it offers us 4 large estates really some tremendous planning opportunities. When we talk about the federal estate tax, this is the tax on property that's transferred at death, and that property is subject to estate tax. It's not just the property that goes through probate, it is truly all of your assets. So if you think through, a lot of the media that was out there a year or so ago around estate taxes was the idea that the exemption would be going back to $1 million per person. And so a lot of people think, well, what does $1 million really mean? If you take all of your assets, your home, your cars, your retirement plans, savings accounts, your personal effects, your furniture, artwork, things like that, and then if you aren't holding life insurance in a trust and you also add in life insurance, it started to be pretty easy for a lot of individuals to cross into that $1 million plus threshold, particularly if you have a young family and you put life insurance in there, that can happen pretty quickly. So this raised exemption, this $5,340,000, really pulled all but the top 0.5% of Americans out of being subject to the estate tax. There's also some exceptions to the estate tax. One of them is property you leave to your spouse will generally not be subject to estate taxes. So there's a full deduction allowed. So in the event one person passes away and the estate is over this exemption amount, they can pass anything over that amount to their spouse without there being an estate tax due. And then in addition, as we discussed in the previous slide, there's also that exemption for gifts. What's important to know is that $5,340,000 can either be passed during life or at death, but it is the same number. You don't get to pass just over $5 million at life and at death. So let's say an individual had given away and used $340,000 of their exemption. At their death, there would be $5 million left, not $5,340,000. So let's look at one more feature also that's out there for married couples, and this is the idea of portability. So oftentimes in the past, when one spouse hadn't planned and the estate documents were set up just to pass everything to the other spouse, one of those exemptions was lost. And so a couple that would have had $10,680,000 between them only had $5,340,000 left. Now, any exemption that is not used at the first spouse's passing can be utilized by the second spouse. I just want to put up a lot of caution flags here, and the one thing I will caution is this is a great benefit in the event someone has failed to plan, but it is not a planning technique all on its own. It's only the exemption of the last spouse. So if someone were to remarry, they're essentially still losing that. if assets grow over time, it could be problematic. So please work with your estate planning attorney and determine if portability is a viable and reasonable option for the way that you might do your estate planning. And I'm going to touch briefly here on the federal generation skipping tax. So as we talked about, there were 3 types of taxes. We had the gift tax. Those were transfers made during life. We had the federal estate tax, and then the third leg that made up the transfer tax system is the generation skipping tax. So early on, when the U.S. was formed, one of the key things was the idea of preventing dynasty wealth. They didn't want the wealth of kings, and they didn't want generation after generation to continue to control the wealth in the country. So years later, the federal estate tax comes along, and then about, 30 years ago now, the generation skipping tax came about. What they don't want individuals to be able to do is say, I've transferred enough, or my children have a substantial amount of wealth, so in order to avoid getting taxed at that generation, I will hand money off to my grandchildren. So I'll go down 2 generations, and that will allow us to avoid estate taxes on these assets for a full generation. The GST basically applies to anyone that is more than 1 generation below you, for example, a grandchild, a great-grandchild, and the person that gets this skip gift is subject to both the GST as well as the estate tax pieces of this. Because generation skipping tax is a separate tax, you get a separate exemption. Right now, the exemption is the same. It's that $5,340,000. Again, this starts to get into a very complex area of estate planning, so I'm keeping this very high level today, but in the event you have a large estate, doing some good and effective planning with your GST exemption is also extremely valuable. So let's look at some of just where the transfer tax has gone in the last few years. I said I would explain where that $5,340,000 comes from. The exemption is actually $5 million indexed for inflation. So what you'll see is from 2012 to 2013, it went up from $5,120,000 to $5,250,000. This year, it's at $5,340,000. You see the top rate on anything above that is also at 40%, and you can see where your GST exemption has gone as well. In the event you have an estate that is over these amounts, I would encourage you to have some discussions around what type of estate planning you should get in place. I also want to say, just because you don't have an estate over this amount, as we started with, does not mean that you don't need an estate plan. You may not need a lot of advanced estate planning, but other needs, children, complicated situations, there are a lot of reasons you need an estate plan in place, not just to avoid the estate tax. One of the most powerful things that we have out there is the ability to gift assets during lifetime. If you think about $14,000 a year, if you have 10 grandchildren and you were passing $14,000 a year to each of them, and each spouse has that amount, so if you were married, you could pass $28,000 a year. But to 10 grandchildren, you could be passing $140,000 per year, every year, out of your estate without using any of that lifetime exemption. Some of the real reasons that people do this during life, on top of just the planning aspects, is the ability to see the gift utilized during their life. I've worked with clients who felt it was very important to pass on not just money, but the value associated with that money and the values by which that money was made. And they use gifting as a way to work with children and grandchildren to say, if I give you this amount of money, what decisions would you make? And what guidance and advice would you like from me? And how could I help you utilize this money well? Another one is it removes future appreciation. I've seen clients, it doesn't just have to be cash. It's very common. I've seen clients with stock in closely held companies, and there are ways to do this. Publicly traded stock that will appreciate. It is a great way to transfer appreciation as well. One thing to keep in mind is the basis in that property also transfers. So there is no step up in basis like there is when somebody passes away. So to give you an example, if you have a house that's worth $1 million and you purchased it for $15,000, if you gift this home to your brother, even though the gift is worth $1 million, his basis is $15,000. If he turned around and sold it, he would pay tax on the difference between that. Another very powerful thing is to keep in mind what's not a gift. There are some very specific pieces, and these are, again, complicated. If you start to think about wanting to take advantage of them, please consult with your advisor before making transfers. Section 529 plans are for education savings, higher education. There are some special rules that allow you to front load 5 years worth of gifts up front. Now, if you do this, please keep in mind that you can't then go gift to the same individual the next 5 years. You have used 5 years worth of gifts and it needs to be spread. A gift tax return needs to be filed. But it's a great way to superfund education if it's something you would look to do for your grandchildren anyway. Another what we call freebie is you can pay tuition on behalf of someone as long as it's paid directly to the school. I had a client trip up with us once who gave the money to his brother, and then his brother paid the tuition. By giving the money to his brother first, it became a gift. But if you pay it directly to the institution, then that falls outside of the gift limits. And then finally, there's no gift tax on amounts paid directly to either medical care providers for medical insurance or an individual's medical care. So the same rules apply. Pay it directly to the hospital, pay it directly to the insurance provider. But these are some things that are also excluded and once again can be very powerful. I know a lot of grandparents, when they talk about legacy, education is a big one that comes up, and this is a great way to take advantage of that. So we're going to go ahead and move forward here into what are trusts. If you're not inclined to make outright gifts, you may want to consider using a trust. And it's a very common, very versatile tool. It can be used as a strategy to minimize taxes. You can have certain property managed professionally. And this goes to that idea if someone either is too young or isn't capable, you may want assets in a trust because there will be someone professionally managing those assets. Also provides safeguards for younger children, elderly parents, because the trust assets will be spent or allocated in the way the trust dictates. And you, as the person who set up the trust, will dictate that. It's also a way to control property, and it can help protect assets from creditors. I think two of the biggest reasons I see individuals set up trusts is, one, the ability to protect the assets from creditors in the event someone were in an accident or they were sued, and then also in the event of divorce, assets that are held in trust, for them, as long as it's a proper trust, are identifiable separate property and don't become part of that. So a lot of people don't know where their children will end up or where their grandchildren will end up, and a trust is a way to help keep the money in the family in the event something were to happen. So if we look at the diagram here, we'll just walk through the real basics. A trust is a legal entity where someone who's called the grantor, so that's the individual who grants the assets to the trust, arranges with another person, the trustee, to hold property for the benefit of the individuals named in that trust, and those are the beneficiaries. So we think about this grantor, individual getting the assets, selects who the trustee will be, also selects who the beneficiaries are, and they will establish the rules by which the trustee can distribute or spend money within this trust. These are very flexible documents. There's a lot of things that you can do with a trust, and there's a lot of flexibility with them. When you create a trust, you've essentially split the ownership of the property. The legal ownership goes with the trustee, and the beneficial ownership goes with the beneficiary. So that means the trustee is legally responsible for managing all of the property in accordance with the trust. Much like being an executor, it's important to note even more so, being a trustee is a job that requires a certain level of knowledge and professionalism, and it does come with a fair amount of liability. If someday the trustees made a decision and a beneficiary disagrees with it, they can absolutely come back and hold that trustee responsible. So when you think about this type of planning and who you might name, there's a lot of reason for using a professional trustee, or make sure it's an individual that understands the responsibility. Oftentimes I'll see the oldest child in the family named as trustee. It's important to keep in mind you've now asked them to make the financial call for whether or not their siblings can receive money. I think it's important to understand there's a lot that goes to that, and when you make that trustee decision, understand that it is a job and sometimes can become almost a full-time job for individuals who are put in that position. So as we talked about, there are really two types of trusts. Trust that you create while you are alive, or living trust. There's also trust that you create upon your death. If a trust is revocable, so a revocable living trust, that means during your lifetime you can change it, you can change the provisions. These are primarily done to avoid probate or deal with incapacity. An irrevocable trust is a trust that is used primarily for transfer tax planning, and this is a trust that only with limited changes allowed during your lifetime. And then the final piece I wanted to touch on today was just life insurance, its role in estate planning, as well as how, when appropriate, to take life insurance out of an estate. So I think life insurance plays a part in almost everyone's estate plan in one way or another. If I think about younger families or smaller estates, life insurance can be a way to almost create an estate. If maybe there are a few $100,000 in assets with a young family with 3 or 4 children, if something happens to the wage earner, the family needs some sort of financial help. And that's where life insurance comes in these cases. And it's really used, we say it creates an estate, but it's used to meet the financial needs of the surviving family members. Life insurance can also provide estate liquidity. We tend to use a different type of life insurance when we do this, but a great example here is if I have a business owner, and oftentimes business owners will underestimate how much their business is worth. So we may have a business owner with a $50 million business, and that if they were to pass away after that exemption, there's about $45 million, little less, that would be subject to estate taxes at 40%. I think if most business owners looked at their business and said, suddenly I have a $16 million liability that I need to pay 9 months from my date of death, they may say it would be devastating to the business. In these cases, life insurance can provide liquidity to pay estate taxes and not allow the business to be harmed. Right now, if you own a life insurance in your own insurance policy in your own name, it will likely be included for estate tax purposes. So that's how, when we say it creates an estate, if you have a $5 million term policy, you could go from not having a taxable estate to, when you put that with your other assets, having one. There are reasons still where people may just hold those policies in their own name, and it's something I would work on with your advisors, with your attorney, to determine if your policy should be held in trust or individually. But if we talk about ways that life insurance can be outside of an estate, the best way is to buy the policy in a trust up front. You can transfer life insurance policies, and there are some nuances to how you go about doing that, and if there's a gift and how much that gift is. But if you do that, you must outlive the policy for 3 years. If you don't, it is pulled back into your estate. So it's not the type of thing to do late in life when someone maybe is terminally ill. It's too late to do that kind of transfer. So the very basic technique here is, first step is the insured individual, which is you, creates an irrevocable trust with your attorney, and you name both a trustee, so who will be in charge of that asset, as well as beneficiaries. From there, your trustee will purchase a life insurance policy on your life, and that policy will be owned by the trust. Step 3, you will make regular cash gifts to the trust. You make these gifts, and then the trust uses those gifts to make premium payments. But there's a key step that has to happen here. In order for those gifts to qualify as what we call present interest gifts, the beneficiaries have to have the right to take that cash, and they have by something called a crummy notice. This is where I will see life insurance trusts fall apart, is the individuals will go to all sorts of work to set it up, buy the policy in it, and then they don't send these notices to beneficiaries. In the event that doesn't happen, you don't have a present interest gift, and you cause problems with the trust itself and excluding all of those life insurance proceeds. So the beneficiaries have to have that right, and they can sign away that right, at which point then the trustee uses that cash to pay premiums. And then at your death, what happens is the life insurance trust receives the proceeds from the life insurance policy, so that trust is holding those. These proceeds are not subject to estate tax because they were purchased outside of your estate, and assuming you followed all the rules that go along with it. And then the proceeds are distributed or held according to the terms of the trust. And finally, beneficiaries will receive full proceeds at the time free from estate taxes, not that after 40% estate tax is paid. So in conclusion, I hope this has been a good introduction and got you thinking a little bit about a few questions. The first one is, do I have a plan in place for incapacity? If I become incapacitated, do I have a plan in place for how both my health care as well as my financial issues will be dealt with? And I think if the answer to either of those questions is no, there really isn't a lot of time to waste. It's something you need to address as soon as possible. The next one is ask yourself, if I have transfer taxes, are these going to be an issue for me? Do I have a complicated life situation, or do I also have an estate that crosses over that exemption amount? And if so, again, you really need to work with a professional and visit about how to go about addressing those issues. And then finally, even if you do have an estate plan, have you revisited it lately? And does it still reflect not only most current law and most current rules, but also does it still reflect your current wishes? I know sometimes we get through this process and we'd like to wash our hands of it. I think it's important to know that you need to revisit that and make sure that on a routine basis that you've updated and kept those documents up to date. So with that, let's go ahead and head into questions.
For anyone who has joined via the phone, you may ask an audio question. To ask an audio question, please press star 1 on your telephone keypad. That was star 1.
So I'm going to go ahead and take a couple questions off the web while we're getting online questions. One question was, do you go through probate when creating a will or after someone dies? And you go through probate after someone dies because remember, that's a process of getting a signature from a dead person. So if we think about probate, we take this will and I'm named as the executor. So Rebecca Robinson is named as the person who's supposed to go and take care of everything. But if I walked into Zions Bank and said, I'm here to take care of Phil's business, the bank says, I can't let you do that because we don't know that you have the legal authority to do so. By going to the probate court essentially now says, based on this document, Rebecca, you do have a legal right now to act on Phil's behalf, and I'm provided the proper documentation. I can then go to the bank and to other places and start gathering those assets. So it's a process that you go through after somebody has passed away. I have another online question here. Regarding gift tax, does the recipient have to pay taxes on it? And the recipient does not have to pay gift taxes on it. The gift tax is on the shoulders of the individual who gifts it. Now, if the individual then takes that money and invests it and earns income, they will pay income tax on the asset. Or if they were to sell that asset at a gain, they would pay capital gains tax on it. But the gift itself is not subject to gift taxes. Let's see what else we have here. So another question is, what is the customary annual periodic fees to professional trustees? All of this answer is the favorite answer of, it depends. A trustee will have a fee schedule for investment management, and that, depending on the size of an estate, could be a blended rate that could be anywhere from 40 to 50 basis points for all of the management and trustee, over, to over 1.5%. There are other assets, too, which are more difficult to manage. So financial assets, such as investments, can be one piece of it, but an individual may have real estate that needs to be managed as well. There are additional costs associated with managing those type of assets as well. In certain cases, if a trust is small enough, the fees may become prohibitive of maintaining that trust, and there are ways to break those trusts as well. But I think when you're looking at planning, every trustee has a published fee schedule, and it's something you could request, and then look at your estate and your assets and get an idea of what would be funding the trust and what the associated fees would look like. So another question here is, does it make sense to have a durable power of attorney for unmarried children? And I would say in general, yes. I know it's something prior to getting married that I had with my parents, simply because as my life became more complicated, I wanted to make sure that there was someone who could make decisions for me and understand what those decisions would be. So I think that's one to consult with your attorney, but it's very likely something that I think does make good sense. Monique, do we have any questions on the line?
There are no audio questions at this time.
Okay, let me see. So another question that just came up was, can a trust also give $14,000 a year to anyone it wants? And keep in mind that the transfer taxes we're talking about are associated with individuals. So I, as an individual, have the ability to transfer $5,340,000. I have the ability to give $14,000 per year. When assets have been transferred to a trust, the individual who did that transferring either used some of that exemption, or they may have used some of their lifetime exemption, but they use that as a way to get those assets into the trust. So when we think about a trust, as its own legal entity, it doesn't have a transfer tax system associated with it, and subsequently it couldn't just go freely give away money. The trust would have to distribute money in line with how the trust document says it can be distributed, and then there's various tax rules that are associated with that. Let me see here. I think, Monique, that is all I have in my queue at the moment, so we can go ahead and wrap up the call, if that's okay.
And thank you again for joining us today. We hope you found this webcast presentation informative. An archive of this presentation will be available 72 hours after this broadcast. This concludes our webcast, and you may now disconnect.